As you can see on the screen there, the clock in the Bryant case has stopped at 2 hours, 5 minutes, and 3 seconds. And that's because the jury has a question, not a verdict, but a question.
Absolutely. It's the Taken teen murder trial where he's been accused of the murder of 16-year-old Susana Morales. Let's go in for the question.
For the definition of malice, in quotation marks, and malice murder, in quotation marks, than what is provided in our jury instructions, signed and dated by the foreperson. If everyone would.
Thank you.
I've had an opportunity to review it, Judge, and I've given it to Ms. Grady for her review.
May I approach you on the bring back?
Certainly, or you can give it to Sheila.
Okay.
Obviously, the answer is no. The malice charge is, I believe, on page 14. Well, the malice murder charge starts at it's the first under offenses charged, malice murder, and then it goes into page 15. I can how would you like me to handle it? I can have the bailiffs tell them that no, I can't, and refer them to page 14 and 15.
Yeah, I mean, Judge, on behalf of the state, I agree. I don't think that there, well, first of all, I don't think there is any additional charge to give.
Right.
I don't know that bringing them in and rereading the charge is of any value, since they have the charge in front of them and copies of the charge for them to read. So either bringing them in to let them know that the law that has been given is all the charges they will receive, or sending that back in a note is fine for the state.
That's fine as well, Your Honor. If you want to refer to the specific pages, that's fine as well.
Okay. No preference on how we handle it. I mean, as far as bringing them out and telling them that, or just sending a note.
Judge, I mean, at this point, I advise, given the nature of the charges and the severity, that we bring it out so it's on the record.
Okay.
The court's answer, because if you send it back in the note, whether or not it's disseminated to all of the jurors is unbeknownst to us. So
Okay.
I think that's the best way to protect the record.
Okay. If you'll bring the jury out, not the alternates.
Yes, ma'am.
Sheila, would you do? Just, I think, yeah. Thank you. I'm just going to refer them to the pages and read the charge again.
And I don't, as on behalf of the state, if you want to read the charge again, that's fine. I'm not requesting that you read the charge, as opposed to just telling them that the charge contained there is all of the charge, is all the law provided by the court. But if you want to read it, that's fine too. I think either way is okay.
I mean, they have a copy. They have a copy.
It's, I mean,
Not necessarily think we need to read it again. You can just refer to the page number. Just say that is the charge and all that they will receive.
okay.
Well, There you heard it. The jury would like the definition of malice and malice murder. I like that they have copies of the instructions with them so they can read those definitions again. But as you heard that, you made the comment, oh, well, that's the issue. That's been the issue all along. Tell us what you mean.
I just always thought that it was going to be a problem because they had no manner of death and not a lot of testimony about how she actually died. Were they going to be able to prove that it was malice murder? And again, the idea is that it's not premeditation. It just means that you had the intent to kill the person, just in general terms. There are more sort of specific terms that they'll be reading from, but at the end of the day, I didn't think there was a lot of evidence of the intent to kill. And as a matter of fact, I thought he was going to take the stand and claim it was an accident.
Me too.
I thought that would be helpful for him. But of course, the cross-examination would have crushed him, so that's why he didn't take the stand. But I thought that might be an issue.
And I think it was smart not to take the stand for this very reason, because we also don't have any evidence of a contentious relationship or arguments between him and her, or did she get in the car voluntarily and maybe he didn't intend it was an accident, it happened. You're right. I don't think there's enough to know.
Yeah, but I think the reason why we heard all of that background information about him, that's what they wanted to supply the motive with, and the idea that this is the type of person that if he is with someone, this was not an accident. This was someone who was not well, who was creepy, and would have murdered this young lady.
I will tell you, in my experience, when the jury has the instructions, it's a little unusual. They come back and say, we need that definition. Does that happen much from your experience?
No, it happens a lot.
Even when they have it.
What they want is clarification. These are words on a piece of paper. It's difficult for non-lawyers to sort of parse through it. But the way the system works, that's their job.
That's fair.
And they're not going to get any clarification. They're going to tell them the definitions as provided to you, page 13 or 14, I think she said, is all you can really do. And it was an interesting point made by the prosecutor saying he wanted it done in open court because if she sends a message, there's no guarantee that they know everybody got the message from the court. So I think it was a good thing.
always ask for it to be an open court. I think that's the right way to do it.
Yeah, I agree 100%.
All right, let's bring in retired NYPD Executive Corey Pegues. Corey, tell us what you think about this question from the jury in this particular case against Miles Bryant.
Well, hey, you're the lawyers there. I totally agree. Especially
good move there, Corey. Good move.
Especially what Mike was saying. There wasn't a whole bunch of information, like you said, where this was, you know, we see these clear-cut cases. This wasn't like clear-cut. They don't have all this evidence, like he snatched off the street and did these things. But I like what you said about the background information. They gave all that creepy information to show what type of person he was.
Is it going to be enough, though? Corey, that's my question to you. You heard it.
It might not be.
You know, and I'm wondering, is it going to be enough for them to get this malice murder conviction?
I like how the defense attorney, doing her closing, you see how she broke down every single charge. And while she was breaking it down, I was sitting there looking at it saying, wow, there could be some doubt with these charges. I don't know if they connected all the dots. I just hope that this family could get some closure. If in fact he is convicted, I hope he is the person that did it and the family could get some closure.
But Michael, I feel like all the evidence was presented. So I don't know that we don't know enough because they didn't tell us. I think we know everything they know.
Yeah, I think we know everything they know. And let's not forget, counts 2, 3, and 4, the felony murder, the kidnapping, and the attempted rape are all being considered. A motion to dismiss is still being considered by the judge. So after the verdict, she'll make a decision as to whether she'll take their verdict or she'll dismiss it because they didn't rise to the level of meeting all the elements.
Which is a little unusual to do it that way, but a lot out there.
Unusual.
Yep, absolutely.
All right.